Can I start?
Yes, sir. Yes, sir.
Okay. Yeah. Good evening, distinguished colleagues, respected faculty member, and friends from India and across the globe. It is my pleasure, honor, and privilege to welcome you all to the first exclusive webinar in the GAPIO Medico-Legal series on Medico-Legal Primer. I am Dr. Sunil Khetarpal, Deputy Director General, Association of Healthcare Providers India, and it is an honor to chair and moderate today's session on behalf of the GAPIO. I extend a very warm welcome to all our delegates joining us from different parts of India and around the world. And since 2020, GAPIO has proudly organized around 150 online academic sessions. And it's the GAPIO's continuing commitment to medical education, professional excellence, and global collaboration. So today's webinar marks the beginning of a dedicated medico-legal educational series, an area that has become increasingly relevant for every healthcare professional, irrespective of their specialty. And medicine today extends well beyond clinical expertise. Every consultation, every prescription, every consent form, every medical record, and every communication with patients carries both ethical and legal implications. So a sound understanding of medical legal principles is therefore no longer optional. It is an essential component of a responsible medical practice. So through educational initiatives like today's webinar, the GAPIO aims to equip doctors with knowledge that supports both quality patient care and professional protection. I would also like to inform everyone that today's session is being streamed live on the official GAPIO YouTube channel, allowing many more colleagues to benefit from this educational program. It now gives me immense pleasure to introduce our distinguished speaker for the evening. And let me introduce you to our esteemed speaker for the webinar, Dr. Ashwini Setya, a highly respected clinician from Medanta Medicity. He is a senior consultant in Medanta Institute of Digestive and Hepatobiliary Sciences, Gurugram, and senior consultant at Holy Family Hospital, New Delhi. Dr. Setya is a medical legal consultant and advisor. He is a visiting faculty at Maharashtra National Law University, Aurangabad, Mahindra University School of Law, Hyderabad, and Delhi Judicial Academy. He is editorial consultant at the Quint and author of the book Medical Legal Issues in Clinical Practice, Practical Solutions, which is under publication. And he has devised, directed, and authored 5 courses on medical malpractice. He has delivered more than 450 lectures in national and international conferences, workshops, and various meetings. So he has several publications in national and international journals. He has more than 100 articles related to healthcare in print and electronic media. So he has been declared one of the best gastroenterologists in Northern India by magazine Prevention and India Today Group magazine for 3 years consecutively. So who better than Dr. Setya for today's webinar? So we are indeed privileged to have him with us. Dr. Setya, the podium is yours. Over to you, sir.
Recording in progress.
Namaskar.
Yeah, over to you, sir.
Namaskar. This greeting of mine goes to all my friends settled in various corners of the world, transcending time zones. That is why I said Namaskar. Because somewhere it is evening, somewhere it is morning, but since it is a global association of physicians of Indian origin, so they would all understand. I thank Dr. Khetarpal, GAPIO, and Doc Plexus for hosting us for this very pertinent, relevant, and important session, as Dr. Khetarpal has already mentioned. Without much ado, I think I would start sharing my presentation. Today's presentation is protecting ourselves. We need to protect ourselves. The medico-legal safety primer, and at the end of it, there are 10 commandments. So let's first see what is the need of this primer. doctors are covered under more than 90 different laws, acts, and applicable regulations. They require 54 different permissions, at least in India. I would make a kind of a comment here that although we are all settled in various parts of the world, but most countries follow common law, and there may be some difference as far as the exact law or act is concerned in a particular country. But since we follow common law, the principles remain the same, and therefore it will not be difficult to understand the basis of medical negligence. And India, at least they can be prosecuted simultaneously in 12 different courts or commissions. For example, under Consumer Protection Act, in criminal courts, in civil courts, Human Rights Commission, National Medical Commission, and State Medical Commission, to name just a few. And remember that this happens to no other professional other than doctors. No one who practices medicine is insulated, including the doctors in government, armed forces, autonomous bodies, and even charitable dispensaries. There is no cap so far on the compensation that can be awarded. Patient can ask for the moon, and believe me, don't be surprised if he's handed over the sun. Prosecution can extend to your heirs if you die. By late career, almost 2/3 of doctors have been sued. These are just the percentages of what specialty comes first, but it may not be to the exact percentage. This is a study which was carried on in the US for some time ago. I am anguished and pained to project this slide where our colleagues have been beaten black and blue, because violence forms one very important aspect of the medical negligence, because people take law in their hand and want to give instant justice, hand over instant justice. Almost 3/4 of practicing doctors in India have faced some form of violence, harassment, or legal complaint during their practice. We find that there are about 5.2 million medical errors that happen every year. Only a small percentage of these errors lead to litigation, agreed, but the absolute number is very substantial. Medical cases now form among the top 5 sectors in consumer commissions. And from last 10 odd years, there has been a very sharp rise noticed. And as you can just imagine, that number of complaints have doubled in Delhi Medical Council itself, and there are almost about 400 complaints every year. Without going into the details of the statistics which I have shown here, just want to impress that at any given time, on an average, each hospital in the country has been or is involved about 4 to 5 court cases decided or settled out of the court or pending at any one point of time in various courts. Now, my first line of this slide says that medical negligence cases filed last year were in higher courts, high judiciary, were more than 65,000. So you can imagine that the total number of cases would be far beyond this, because the cases in district commission, where we are fighting most of our cases these days, are not reportable. So then let's see what is negligence. By definition, negligence means a lack of proper care. Therefore, it necessarily is only subjective, cannot be precise, because there are no measurements of negligence. So it is defined in plain English as lack of reasonable care and skill on the part of the doctor in the treatment of a patient, whereby the health or life of a patient is endangered. And simply explaining, it is opposite of diligence. Both of them are subjective, as I told you. It consists of 2 acts, those of omission and commission. What is omission? the act of not doing something which a reasonable doctor under the same circumstances would do. For example, I am a gastroenterologist, so natural examples come to my mind are from gastroenterology. For example, a patient comes with hematemesis in the emergency room, and the casualty medical officer, in his great enthusiasm, just refers the patient straight to the endoscopy room for endoscopy without measuring the blood pressure. What is the negligence of commission? Doing something which a reasonable man under the circumstances would not do. The example given is, say for example, the same example, that the endoscopist also goes ahead with the doing endoscopy without measuring the blood pressure, without knowing whether the patient is in shock or not. Now, in the legal parlance, there is something called as actionable negligence. Negligence where the action can be taken. 4 factors need to be met before we call a thing or a definition of negligence be actionable. First, there is a duty of the doctor towards the patient. Now, any patient who comes to your chamber or you are seeing, the duty of care sticks to you. Duty of care adheres to you. Second, there has been a breach or dereliction of that duty. Third, the damage has been caused to the patient. But most important thing is that the damage is consequential, which means that there is a nexus between the dereliction of duty and the damage caused. I'll give you a small example. There was a case in one of the big hospitals in the country where a patient, before being taken up for surgery, was subjected to a rectal examination. Patient, during the rectal examination, died. Now, certainly the rectal examination cannot be fathomed as a cause of death of that patient. So, although there was damage, and also there was no breach or dereliction of the duty which was alleged, so the case fell. What is breach of duty of care? Doctor has fallen below the standard of care prescribed. That is the standard of care expected from a reasonable man under the same circumstances. Now, reasonable is a term which will come very frequently in all the legal cases. Reasonable patient, reasonable doctor, reasonable case, reasonable definition, etc., etc. Having said that, the reasonable then measures up to what is thought by the judge of that particular day. What is breach of duty of care? That which departs from standard practiced by a responsible body of medical persons skilled in a particular area of the medicine in question. Now, remember that standard of care is judged by standard of an average practitioner of the class to which the doctor belongs or holds himself to belong. Now, what does that mean? For example, a physician who is an internal medicine specialist calls himself a cardiologist. Then the standard against which he is going to be weighed is that of a cardiologist. Failure to conform to required standard of care resulting in material injury is an actionable negligence. Material injury means significant injury, which can affect the outcome of the case or which can influence the case itself. As I mentioned, expected standard is higher in the cases of specialist versus GP, hospital versus primary health care, OT versus wards, and they may be perfectly more than one proper standards. Now, what is not negligence? Error of judgment is not negligence. Accident during a procedure or treatment is not negligence. Very important, inherent complication well explained at the time of consent and consent taken is not negligence. An act done in good faith is not negligence. Although I, often think, or often it's to my amusement, that which doctor is the one who would do an act which is not in good faith? But since it's a legal definition, it is a legal definition. A simple lack of care is not negligence. To give an example, if you have put in an IV cannula for IV fluid and have secured this with a micropore, and that has come out after about 10 minutes and the blood starting oozing out, that is not negligence. It is just a simple lack of care. The standards of judgment are those of a reasonably competent man and not of the most skilled in that field. Following a practice acceptable to medical profession on that day, even if a better alternative was available, is not negligence. To give you another example, these days, anything and everything, every complaint, at least in gastroenterology, is investigated with the help of endoscopes. If the patient comes with a pain abdomen and you've ordered a barium series, although it is a kind of an obsolete thing, but it is still acceptable to medical profession for certain indications. So it certainly is not negligence. The remedies are under 4 laws. One is consumer law, where most of our cases go, where the compensation is payable for deficient services. Then comes criminal law, when any grossly negligent act is done, because here the purpose is to give punishment to the doctor and not take compensation. Law of torts is what is done in civil court. Actually, the civil law also governs the consumer law also. Law of contract, we are entering into a contract when we are seeing a patient, when we are doing a surgery, when we are doing a procedure. Consent is nothing but a contract note. So we are governed by law of contract also. A word about Consumer Protection Act 2019 and what all services are included. So it's a blanket statement that I can give. Services by any medical practitioner except when he sees everyone free. Government hospitals where some people pay and some services are payable. What is the example? Say most government hospitals, at least in Delhi or elsewhere also, they have most of their services, including admissions, treatment, etc., absolutely free of charge. But certain expensive or less available investigations are payable, which means, say for example, CT scan, or say for example, PET scan, wherever in the government hospital it is there. Now, a person who gets PET scan is fine, but a person who's not needed even the PET scan or any payable service can still sue the hospital despite the fact that he has been treated completely free of charge. Services which are out of purview of Consumer Protection Act is simple, where everyone is seen free of charge. There is something called as contract of personal service as opposed to contract for personal service. This contract of personal service is usually given by the employer to the employee, and contract for a personal service is where the person who gives the service does it on his own, with his own mentation, etc. Again, it is bad that I have to project this slide. See, Consumer Protection Act applies to all paid goods and services, but the only place where free services are covered under CPA is the medical profession. There is a draconian provision. In 1986, the Consumer Protection Act, Section 3 and CPA 2019 in Section 100, they state very clearly that provisions of the law shall be in addition to and not in derogation of other laws for the time being in force, which means this provides for prosecution of doctors under multiple laws in addition to CPA simultaneously. We come a few words about criminal negligence, because this has attained very importance recently after the passage of Bharatiya Nyaya Sanhita, which was earlier, which has replaced Indian Penal Code. Here, the objective is to punish the doctor and not get damages. So, degree of proof required and evidentiary standards are beyond an iota of doubt. Since it's a definition, I'll read it verbatim. Gross and culpable neglect or failure to exercise that reasonable and proper care and precaution to guard against injury, which was imperative duty of the accused, is what is called as criminal negligence. Supreme Court has distinguished between negligence, rashness, and recklessness in Poonam Verma versus Ashwin Patel case. What they have said is that a negligent person is one who inadvertently commits an act of omission and violates a positive duty. Positive duty, I told you earlier also, sticks to you whenever you take care of a patient. A person who is rash knows the consequences but foolishly thinks that they will not occur as a result of her or his act. A reckless person knows the consequences but cares two hoots. And the court has said that any conduct which falls short of recklessness or deliberate wrongdoing should not be the subject of criminal liability. Now, doctors in India and criminality, this is something which I wanted to lay stress on, although criminal law itself and criminal negligence itself would be a topic for a whole one-day conference. So section 106(1) of Bharatiya Nyaya Sanhita, BNS, which has replaced 304A of IPC, says that whosoever causes death of any person by doing rash or negligent act not amounting to culpable homicide shall be punished with imprisonment, which may extend to 5 years, and shall also be liable to fine. If such an act is done by registered medical practitioner, that is a doctor, while performing the medical procedure, he shall be punished for 2 years and shall also be liable to fine. For the first time, medical negligence has been specified to be brought under this section. It was not there. The term medical negligence was not there. In the erstwhile IPC, the punishment was for 2 years or fine or both. Now, earlier on, what used to happen is that if the doctor used to be hauled for criminal negligence, in many cases, if not most cases, he would get away by paying a fine and will escape jail term. Under the current law, imprisonment and fine both are mandatory. I would like you to please lay some attention to this, what I'm going to tell you now. 117(1), don't go by the whatever is written here as far as the narration is concerned. It defines what is grievous hurt. So, whosoever commits an offense or causes grievous hurt to a person which causes that person to be in permanent disability or in persistent vegetative state shall be punished with rigorous imprisonment for a term which shall not be less than 10 years, but also may extend to imprisonment for life, which shall mean the imprisonment for the remainder of that person's natural life. Similar section, all it says is that here there is a use of acid which was meant for somebody else, but also it says that or by using any other means, throwing acid or by using any other means with the intention of causing or with the knowledge that he is likely to cause such injury or hurt or causes a person to be in permanent vegetative state shall again be punished for the same term which I told you just now, but also with fine, provided that such a fine shall be just and reasonable to meet the medical expenses of the treatment of the victim, and it will be given to the victim. Now, see, the thing comes that whenever you operate upon a case, by definition, it is always a grievous hurt. You cut open, right? And also you have the knowledge that the patient may have problem during the surgery of anesthesia and so many other things. So with the knowledge that it is there, My problem is that section 117 and 124 of BNS, because of their ambiguous language, can be misused by police. We know, all of us know, that permanent vegetative state may occur after a patient who's stuck. We do it every day in the ICU when there is CPR given. Patient may suffer a permanent vegetative state or may recover. Now, let us say I decide not to revive that patient after cardiac arrest. This is not only against the tenets of medical ethics and Hippocratic oath, which we are all under, but also against the law laid down by Supreme Court in Permanent Katara versus Union of India case. The doctor would always be apprehensive because there is a sword hanging over his head, that if the patient dies, he is held negligent under section 106 and the punishment is 2 years. But if the patient recovers but is vegetative, he can be in for life. We all know that there is no way to predict who is going to die and who's not, and who's going to be in the vegetative state. Now, I'm not talking in air. I must admit that under this act in the last 2 years, so far there has been no conviction in the criminal case. Having said that, I wanted to bring out this particular case law, wherein in Kanchipuram District Consumer Dispute Redressal Commission, the man was awarded more than 51 lakhs, whose mother went into a vegetative state after suffering anaphylactic shock due to administration of injection ceftriaxone. In addition, in addition to the lump sum, the hospital has also been directed to pay 75,000 rupees a month as maintenance to the plaintiff for life. I published these laws in Times of India about a couple of years ago, because we always work under threat of violence, and new harsh laws, they stoke fear all the time. Coming back to the subject of criminal negligence, so in Jacob Matthew versus State of Punjab, the Supreme Court has said that a private complaint of a rashness or negligence against a doctor may not be entertained without prima facie evidence in the form of credible opinion of another competent doctor supporting that charge. In addition, the investigating police officer should give an independent opinion, preferably of a government doctor. Finally, a doctor may be arrested only if the investigating officer believes that the doctor would not be available for prosecution unless arrested. Also, both former Chief Justices of India, Justice Sadashivam and Ranjan Gogoi, in 2018 held that no FIR can be filed against a lawyer and by inference against a doctor just because his advice was unacceptable. But believe me, the ground reality is completely at variance. Practical aspects are that these sections which I've quoted are cognizable and bailable offenses, which means that the police would hold investigation but has the authority to arrest without warrant. God forbids, in case somebody is hauled up against these acts, under these acts, do not spend time, money and energy rushing to the court, because bail is a statutory right and police is bound to give you bail. There is legal safety net under these sections. BNS 18, accident in doing a lawful act in lawful means is not an offense. BNS 19, it permits causing harm with an intention to avoid greater harm. For example, a patient has got gangrene and you would like to amputate his leg just to save his life, then it is certainly not criminal negligence. The only thing is that in this particular case, consent of the patient is most important requirement. And we should also document the medical reasons that should indicate that the harm to be avoided far outweighs the risk of harm caused by the decision to terminate life. I wanted to avoid this example because this euthanasia and advanced directive are completely different issues which one needs to discuss at length. Section 26, nothing is an offense by reason of any harm it may cause to the other, provided that the act is done for the benefit of the other and in good faith. And he has given an express consent, provided also that the doctor in this has no intention to cause death. Now, how not to get into this cesspool? From the institution's viewpoint, train, train, train. You must continue to train the public, the people who are there, and train the trainer. Must co-opt medical advice, medico-legal advice in any complaint or in any such case which goes to the court. See, right now what happens is that the lawyers are handed over the case. But as has been mentioned, even in Jacob Matthew case, that neither the plaintiff's lawyer, nor the defense lawyers, nor the judge know anything about medicine, or at least the intricacies of medicine. So they are lay people as far as the medicine is concerned. Therefore, you must co-opt a medico-legal advice in any complaint or case. How not to get into this cesspool? Remember the first 5 letters of English alphabet, A, B, C, D, and E. Be aware, build structures, communicate, document, and empathize. I'll come to that. You should be aware that there's no one who's insulated against lawsuits, that you are primarily responsible for your acts and omissions, but are also responsible vicariously for acts and omissions of your subordinates. If you ordered something to be done by a resident and he does something and there is a mishap, then you are equally responsible. You must be aware about the rights of the patients, about your own duties, rights if there are any, although I doubt if the doctors have any rights, and the laws that govern you, about your defenses. Remember, please, I cannot overemphasize that if you criticize your colleague today, it may be your turn tomorrow. Please do not criticize. Just say that, okay, he might have been the best person at that particular time, but this is my view and this is my treatment. What are structures? Structures are the pointers showing due diligence and sifting past records that you have done something. Consent, hard copies of which should be preserved. Various other certificates which either you have issued or have been issued in the past. Family meeting records, very, very important. Another thing is, please do not alter material facts on patient's request. Docs are, please do not write that I have been suffering from diabetes for the last 10 years because I've just taken the insurance policy 2 years ago. Docs are, please do not write that I've been drinking because the insurance would be denied. I am again very upset in projecting this statement that be on guard always, because every patient is a potential litigant. Please don't brand me as cynical, but I want to be very, very careful about this. Be a good listener. Body language sometimes conveys far more. See, most of the cases that come is where communication has failed. So that's probably the most important. If you remember my previous slide, I have made C and D as bold. These are the 2 pivots on which the case is, the edifice is held. Communicate in a language that patient understands. States the fact as they are without overt sentiments. Prognosticate correctly and realistically. In sick patients, please communicate frequently. Communicate with patient and immediate family only, because maintaining confidentiality is mandated by law. Document, I cannot overemphasize the importance of this. You should write detailed notes in subjective, objective assessment and plan pattern. Procedure and surgery notes should be objective and not vague. Please do not cook up, do not change, write addendum instead. Consents, as I mentioned, hard copy should be preserved. So is the certificates, and issue only in genuine cases. Get the family to sign the briefings. That's very important, because that is what the documentation is. The case comes up after 10 or 15 years. At that particular time, nobody remembers what happened. So get the family to sign the briefing, because when the patient is under your care, you are God. And when the patient gets better, you become a human being. And when you present your bill, you are almost a shaitan. Many cases have been decided because doctors' notes and nurses' notes did not tally. The vitals taken by the nurses were not the same as what were written by the doctors. So you must make sure that doctors' notes and nurses' notes must tally. Give rational, reasonable, and explanation, especially when the complication occurs. What do I mean by giving these explanations is to write reflective notes. Why did you take that particular decision at that particular time? Document the communication. Communicate the documentation of communication. That acts as a real deterrent. That whatever has transpired between the two of us, I've already written that. Do not lie, because you do not have to remember the truth. Whatever happened, you would always remember. But if to cover up, you say something you would not remember 10 years down the line. Extremely important. One can expect unreasonable, irrational response from a patient who's under stress and grief. Somebody kith and kin have died. Obviously, he would have some agitated response, or which are irrational. Please do not overreact. Avoid direct confrontation. Be polite but firm. Empathy and compassion have won many a battle. And in fact, a sympathetic touch can avert a lawsuit. A few more points which I would like you to please understand, that malpractice insurance in today's day is must. Hospital policies usually cover the full-time employees. If you are visiting, then you should have your own insurance. Be heavily insured. Take personal indemnity insurance and error and omission policy for clinical establishments. You have a clinic. Error and omission policy is that there are unskilled helpers you have, and they are just getting either the wheelchair or getting the patient from one place to the other, and the patient meets with an accident by falling. Then you are sued, but you are covered if you have an error and omission policy for clinical establishment. Include names of all the hospitals you visit, and include names of all the doctors who visit your clinical establishment. No liability of insurer accrues if the procedure performed is under influence of narcotics or intoxicants. Your credentialing should be up to date. Very, very, very important. There are other safeguards in consultation clinics, small nursing homes. Train your staff to be alert to aggression from outside. Install CCTV cameras, security systems, and panic buttons. Make groups of colleagues in the neighborhood use technology and social media to broadcast the emergency. In complicated cases, do not deny the patient a second opinion on being asked. Call another expert, especially during surgery, if the situation so demands. No ego, please. Encourage formal peer reviews. They carry a lot of weight when you present your case in the court. As far as practical and possible, refrain from giving an opinion on phone to a new patient. Please keep in mind the new telemedicine guidelines which have been issued. New means the ones which were issued with the advent of COVID. Know the local area SHO. Be active in local branch, IMA, and other professional and social platforms, because networking helps. This should be my last slide. When you get a legal notice, exploitation starts by patients and relatives. Politicians, police, pleader, media, protection groups, and social workers, and your own jealous colleagues. And your reaction then becomes you are confused and panic-stricken, trying to hide the facts or alter the records or influence the situation by money power, political power, or any other clout, because the legal phobia starts. But you must think positive, stay calm, avoid anger and surprise, and panic and self-doubt. Immediately, please, for heaven's sake, immediately inform your insurance company. Discuss immediately with medical legal expert and lawyers. And remember that discuss only with your spouse or highly trusted senior colleague, no one else, because in the court, that person may be taken a witness against you. Thank you for your attention. Thank you very much.
Noted. Yes, thank you very much, sir. Thank you, Dr. Setya, for an exceptionally insightful and practical and thought-provoking presentation, which you have today. In fact, given us the overview of the medical negligence, what constitute medical negligence, what is negligence, what does not constitute medical negligence, and you also highlighted the key provisions of CPA 1986 and 2019, and the draconian provisions of the Act, including few provisions of Bharatiya Nyaya Sanhita, that is BNS. So I think what do we gather here from his talk is that no doctor or no hospital is immune to the litigation by the patient. Every patient is a potential litigant. And their alarming data, as what he has shown us, is that 75% of doctors have faced some form of violence in their lifetime. This is something very alarming. And he very aptly touched upon he guided us on how do we safeguard ourselves from litigation. So that was also very relevant for all of us. Sir, your talk has beautifully highlighted that medical legal awareness is not about practicing defensive medicine. It is about practicing responsible, ethical, well-documented, and patient-centric medicine. But we have received a number of questions through the chat box. I would just like to go through them. With the first question is about what should a doctor do if they suspect a case has a medical legal implications, but the patient refuses to register it. Can you share common real life situations where doctors are at higher risk of being accused of criminal negligence? This question is from one of the participants. Yes, Dr. Setya.
So see, if you suspect that there may be, you must smell rat. It depends on the patient's behavior while you're treating the patient. Patient and the relatives become more aggressive, then you should think that he may go to the court. It is great if he's not going to the court. Wonderful. But you must be prepared. How are you prepared?
Yes.
If you even suspect there is a whiff of doubt or iota of doubt that this patient may go to the court or may complain even to the hospital authorities or state medical commission, please inform your insurance company. Very, very important. Whether or not you've received the notice, this is the time to inform your insurance company. That's one preparation. Second, there has to be a basis why you're suspecting that there may be medical legal implications of that. So you prepare yourself, your defenses very well. Go to the literature, see what you might have done. Go to the literature, search out the latest, and speak to medical legal expert of your hospital or otherwise. If you feel that it may be that you must be prepared both ways, the insurance as well as your own defenses. Common real life situations occur every day where you could be hauled up for criminal negligence. I mean, it is not just death by negligence. It is so many other things. Criminal negligence is when, there are sections which I didn't want to elaborate because the criminal negligence itself is a complete big law. Even a small thing like a section is there, I think it is 125, where you are supposed to have ignored a thing and no harm has come to the patient, but even then you are hauled up for criminal negligence. I'll tell you why. Let's say you are in the OT and the oxygen cylinder is empty. You are done. If whether or not the oxygen was required in that particular case, you are done. You're done doing a surgery in local anesthesia, but somebody says, even a technician says loudly, "Oh, ye to cylinder khali pada," you are done. So there are multiple such sections under which you can be hauled up. You must do due diligence. That is what is important.
Right. Sir, thank you for answering this question. And I have another question from a participant. If a doctor refuses a higher risk cases due to lack of resources, can that be considered criminal negligence?
Not at all. You already refused. You have already refused, and you've told the patient there are no resources. Please take, either the human resources are not there or the equipment is not there. You have admitted, in fact, you should be lauded for that. Certainly not.
Right. Another question is about civil law and the criminal law. Why are most medical negligence cases handled under the civil law rather than criminal law?
See, most 99% of the cases are being handled, taken up by the consumer courts these days. And since this is not a lecture on Consumer Protection Act, but I must tell you that today, if it is earlier on in 1986 Consumer Protection Act, the jurisdiction of the courts was based on what the claim amount is.
Right.
Right? Today, it is what the amount of consideration. Amount of consideration is amount of the bill.
Yeah.
So is less than 50 lakhs, the bill, the consumer court that deals with it is district consumer court. Between 50 crores, 50 lakhs and 2 crores, it is the state commission. And beyond 2 crores, it is the national commission which deals with it. So 99% of the cases will be dealt with by the district consumer dispute redressal commission. Criminal negligence occurs only when the patient is so agitated because of a death or loss of limb or something of that sort, very serious, only then. That is why, and the patient's aim there is to actually get money or compensation, and that is why they don't go to criminal cases. But as I mentioned, you can be sued, you means anybody can be sued simultaneously in criminal as well as consumer, as well as civil, as well as human rights commission, etc., etc. That is what my problem is.
Mm-hmm.
It happens with no other professional.
Well, right, sir. So another question, this is the last question in the chat box about the professional indemnity, that how important is a professional indemnity insurance and what should doctors look for while choosing it?
So let me just start from a negative part. Please do not omit to read the insurance policy when you buy it. The fine print must be read. There are many things which are denied to you. In fact, sometimes the insurance company, if I may use that analogy, they may stab you in the back. But it is a necessary evil. You have to have an insurance policy. And my advice to you would be that 1:1 policy, which is any one accident in any 1 year, you must take. There's a difference. There's a difference. 1:1 policy and 1:4 policy, for example.
Mm-hmm.
What happens is that they cover 4 accidents in a year. And they tell you that the premium would be much less. So you buy this. All the sum insured is the same. Now, let us say that you've taken a policy of 1 crore. Incidentally, nobody should be having a policy of less than 1 crore. Nobody. If it is a surgeon or a person like endoscopist or interventional cardiologist or somebody, they must have it at least for 2 crores. So if let us say that you have a policy of 1 crore, which is 1:1, which means any one accident in any 1 year, or 1:4, then 1:4, you are covered for one particular case only for 25 lakhs. That is the problem with that. That is the what is called as, that is the trick. They sue that. So you should, that is one part. Secondly, what you should see is, remember one more thing, that if you are insured, you are not going to be defended in the criminal courts. No, sir. It is only the compensation they are concerned about. You are neither represented in the criminal courts, nor you're represented in the state medical council. Because state medical councils frown upon any attendance by the lawyers from any side. They want you to be there. We can have, I mean, every such question will demand one full lecture of 1 hour.
I do not see any more questions in the chat box, sir. I think we are well on time. So thank you, sir. Thank you once again for your very valuable insight and also answering all the questions. We have come now close to the end of this session today, and I would like to express my sincere gratitude to our distinguished speaker, Dr. Ashwini Setya, for sharing his expertise, his practical wisdom, and his valuable guidance on this extremely important subject, which is the also our most neglected subject. And I'm sure our audience has gained several practical take-home messages that they can immediately incorporate into their daily clinical practice. I also thank all our participants from India and around the world for your enthusiastic participation, your thoughtful questions, and continued support for this GAPIO's academic initiatives. My sincere appreciation goes to the leadership of GAPIO for conceptualizing and supporting this dedicated medico-legal webinar series. I also acknowledge our digital outreach partner, DocPlexus, and the technical and IT teams whose efforts have made today's live webinar and YouTube streaming possible. So before we conclude, I would like to make one important observation, which has also, I think, Dr. Setya has also talked about the same. He's touched upon it. You know, the Association of Healthcare Providers has filed a significant writ petition before the Honorable Supreme Court seeking the exclusion of doctors from the ambit of the CPA Act. And after the Honorable Delhi High Court in July 2025, they advised the HPI to approach the Supreme Court. So that's how we filed a writ petition in the Supreme Court. And the writ petition was admitted in the Supreme Court, and notices have been issued to the government and the National Medical Commissions, with the next hearing scheduled for 28 July 2026. So some of the organizations has also implemented and or have filed a separate writ petition or are in the process of filing the writ petition. So final ruling will decide whether doctors remain under CPA or are excluded. So the case presents an important opportunity for judicial review of the professional status of the medical practice. Now, we argued that AHPI argued that medicine is a profession which is founded on clinical judgment, ethics, and fiduciary trust, not a commercial service, and that excessive litigation promotes defensive medicine, increasing healthcare costs and adversely affecting patient care. So our discussion today has been purely educational and intended to improve the professional awareness, patient safety, ethical practice, and legal preparedness. It should not be construed as legal advice or commentary on any pending case. So this is just, I wanted to request all the participants to make a note of it. But finally, the key message from today's session is very simple, that good clinical practice, compassionate documentation, because the compassionate communication, because communication is very, very, very important, and we all lack in communication. And the documentation, which should be a meticulous documentation, and documentation is a good defense in the court of law. The informed consent and continuous learning remain the strongest safeguards for both our patients and ourselves. So thank you once again to Dr. Ashwini Setya for enlightening the medical fraternity on the very important topic. And thanks to GAPIO, Dr. Sushil Jain, Jitendra Malik, to our digital outreach partner, and to every one of you for making today's webinar a great success. So we look forward to welcoming you to the next webinar in this exclusive GAPIO Medical Legal series. So until then, stay safe, continue learning, and continue serving humanity with excellence. Thank you so much. So
we are well. Dr. Kejriwal, thank you very much for
thank you, sir.
And Dr. Kejriwal, GAPIO, and DocPlexus for hosting us for on this important issue. And I just wanted to say, as a piece of information which you mentioned, just as an extension of that, that we at Medicolegal Action Group, I'm the secretary of that, we are also pleading in the same case.
Right.
We have earlier lost out in the Bombay High Court and in Supreme Court also, but I think with AHPI we should win.
Sure, sir.
Thank you so much.
We all
Thank you
should be
once again.
united.
Thank you very much.
Thank you very much.
Thank you, sir, on behalf
Thank you,
of
sir.
Dr.
Thank you.
Thank you, Shifa. Thank you. Thank you, Nitin. Thank you,
So much.
Jitendra. Thank
Thank
you.
you, sir. Thank you.
Okay. Thank you, sir. Thank you, Dr.
Thank you.
Setya. Bye.
Thank you, Doctor.
We are well on time. Thank you.
Thank you, sir.
Great.